largely commemorative days plus the Senator Washington bill, but it should be quick, sponsor-only stuff. So we'll have time to, whatever we don't get to, do some more voting tomorrow. But let's start with some, I guess, what I would characterize as some priority bills in the view. Stacey, why don't we, well, before we do that, April wanted to bring something to attention. We do have a bill on the floor that we might need to put a sponsor amendment on, and April feels she should at least make sure that we agree to allow the senator to have his name on the bill. So tell the committee.
So this is Senate Bill 186. That's the blue catfish pilot program bill. If you recall, it was taking provisions from Senator Moutz's bill, rolling them into Senator Bailey's bill. I had reached out to Senator Moutz to ask if he wanted to be added as a co-sponsor. He got back to me a little late, but he does. If people are okay with it, the committee amendments have not been finalized yet, so I can just roll that in.
Okay, so everybody okay with having Moutz added to the committee amendments as a sponsor? All in favor? Okay, that's all good.
Thank you.
Okay. Sure. Senator Kagan also has a floor amendment that.
Thank you, Mr. Chair. Senate Bill 929, Senator Brooks's bill to create a work group for how people with disabilities vote, what their options are and stuff, vis-a-vis cybersecurity and all that. I've got a floor amendment that Senator Brooks has seen that I'll be bringing to the floor. It just says shall consult with NIST and NIST, the National Institutes of Standards and Technology, which has just internationally known election security stuff. And I don't have all the language, and adds another couple security experts to have the work group be a little more balanced. Don't know if there's anything you want to add, Senator Brooks.
It adds, it strengthens the security part of it, so I would consider that a friendly amendment. Yeah.
Okay, is everybody? I don't think we need to take a formal vote. Is everybody okay with that floor amendment? With that said, let's start with Stacey on Senate Bill 308. Senator Simonera.
Senate Bill 308, Election Law, Chief Election Judges, Party Affiliation. This bill modifies provisions governing the party affiliation of chief election judges and other election judges assigned to a polling place. The bill requires that a polling place have an equal number of chief judges and other election judges from the majority party and principal minority party to the extent practicable. However, if an election director designates 2 chief judges for a polling place, is unable to designate one from each party at least 45 days before early voting, the election director must designate 1 chief judge from the majority or principal minority party and 1 chief judge who is not registered with either party. So there are no amendments to this bill.
Okay, any questions for Stacey on Senate Bill 308?
I have a question.
Yes, Senator Watson.
Since my father served as a chief judge, are you telling me that at a poll there will be 2 chief judges?
Yes, that's the current practice in general. They try to do bipartisan teams of chief election judges, correct?
Really?
Yeah.
Okay. All right. Thank you.
Okay, any additional questions for Stacey? Okay, there are no amendments.
There is about to be.
Oh, okay. Okay.
Yep. So do the motion on the bill first.
Well, no.
Move the bill.
You said you have an amendment.
I'd like to be added as a co-sponsor on this important bipartisan bill.
Okay. Well, let's take the amendment, a sponsorship amendment up first. Who would like to be on the bill as a co-sponsor? Raise your hand. We've got Senator Kagan. Anybody else? Senator Brooks? Okay, we have Kagan and Brooks. Okay. All in favor of the Kagan-Brooks sponsor amendment, raise your hand. All opposed? That amendment carries. We have Senate Bill 308 with that amendment on the table. Is there a motion?
Move favorable.
Vice Chair Kagan moves favorable. Is there a second? Second from Senator Brooks. All in favor of Senate Bill 308 as amended, raise your hand. All opposed? That motion carries unanimously. Stacey, could we just, maybe let's stick with you on, let's go down to 310 maybe, just go 310, 318,
310,
342.
okay. Senate Bill 310, Education, Youth Suicide Prevention School Program Revisions. This bill expands the educational programs authorized under the Youth Suicide Prevention School Program to include classroom instruction designed to increase pupils' awareness of the relationship between gambling and youth suicide. The bill likewise expands the findings and declarations of the General Assembly to include 1, youth suicide often exists in combination with other problems, including gambling addiction, and 2, that a suicide prevention program for young people must recognize student behavioral health issues, recognize students experiencing trauma or violence out of school, and refer students to behavioral health services. There's one amendment that was handed to you as walking around from Senator Simonaire, and this makes a minor change where before they must recognize student behavioral health issues, it said should promote. Is that correct? Okay.
That was from mental health. We had worked on that. So with the amendment, there's no opposition.
Any questions on this amendment from Senator Simonaire? Okay, Senator Simonaire, you want to move your amendment? Amendment's moved by
Second.
Senator Simonaire, Vice Chair Kagan, second. All in favor of the Simonaire amendment to the Simonaire bill on 310, raise your hand. All opposed? That motion carries. Senate Bill 310 as amended is before us. Senator Simonaire moves the bill. Senator Washington second. All in favor of Senate Bill 310 as amended, raise your hand. All opposed? 310 carries unanimously. Let's just go to 318, Stacy.
Senate Bill 318, Higher Education Janet L. Hoffman Loan Assistance Repayment Program to include veterinary practitioners and veterinary technicians who received a graduate, professional, or undergraduate degree from an accredited veterinary college or university. Veterinary practitioners and technicians must also have provided veterinary services or veterinary technician services as an employee in the state for a period not less than 5 years or as a volunteer for a minimum of 100 hours per year for a period not less than 3 years at an animal shelter that's owned by a local government, an organization contracted to perform animal control services for a local government, or an organization that shelters animals and was a recipient of the Maryland Spay and Neuter Grants Program during the prior year. There is one amendment offered by the sponsor, Senator Lewis Young, and there's a co-sponsor request from Senator Hester. The amendment essentially corrects a drafting error. The program was accidentally included under the Nancy Grasmick Public School Professional Award part of the LARP, and it's obviously not meant to be part of that. So you can find that on page 12 of your packet.
Okay, we have this, it's a partial sponsor amendment as well as this technical corrective amendment. Would anybody like to move that amendment?
Move.
Vice Chair Kagan moves the amendment, second from Senator Washington. All in favor of that amendment, raise your hand. All opposed, motion carries. Senate Bill 318 as amended. Is there a motion?
So moved.
Favorable by Senator Hester, second from Vice Chair Kagan. Discussion? All in favor of Senate Bill 318 as amended, raise your hand. All opposed, that motion carries unanimously. Stacey, let's go to 342 next, Senator Sidnor.
Senate Bill 342, the Voting Rights Act of 2025, Counties and Municipalities. The bill establishes a specified prohibition against the impairment of the ability of members of a protected class, members of a race, color, or language minority group, to elect candidates of their choice in elections in a county or municipality or to influence the outcome of such elections. It includes factors, considerations, and criteria related to the establishment of a violation of the prohibition, and authorizes a person to bring an action to enforce the prohibition in the county or municipality where the alleged violation occurred. The bill does not apply to statewide elections. There is an amendment in your packet beginning on page 14 from Senator Sidnor. And this amendment combines the requirements for counties and municipal corporations into a single subtitle where previously it was broken into separate subtitles. It provides that a violation may be established by a method of election that dilutes or abridges the voting strength of a protected class can be demonstrated by the existence of one or more methods of election that could be constitutionally adopted that would likely mitigate the dilution. in authorizing a certain factor to be considered for determining a remedy, in providing that a court may consider specified evidence in determining whether a certain violation has occurred, and then it authorizes the Office of the Attorney General and any other person to bring an action to enforce the provisions of this act, where the bill just says any person, and adds a severability clause providing that a holding of the U.S. Supreme Court that affects the application of a provision of the act does not affect other provisions or applications of the act, and the affected provision is severable from the remainder. I should note that after these amendments were drafted, Senator Signor and some of the stakeholders brought in just two minor corrections to these amendments, where the severability clause was a holding of the U.S. Supreme Court. It would allow for any holding of any court that was contrary to the provisions of this act, that it would be severable, the remainder of the provisions, and that under a specific prohibition, there was an or in the amendments, and they are requested that it be an and, so that both components would have to be present in order for a violation to occur.
Vice Chair Kagan.
Mr. Chair. First, I want to just give a shout out to Senator Sidner, who's been working on this issue for many years and has been diligent and collaborative and thorough and thoughtful. And I just really want to applaud him, because I think this is a really great piece of legislation that I am hoping will move all the way through and become law. Second, I want to just thank Stacy, who's been just so connected and thorough and all that. And then third, I want to acknowledge the advocates. So whether it was League of Women Voters or NAACP, the ACLU, there are just a lot of election experts and community leaders who've been involved with this. And so I think this is a great document, and I'd like to move the bill and move the bill first, and then we can talk about the amendments. Move favorable on the bill.
Okay.
Yes.
First up, let's take up the, okay, well, on the bill, Senator Hester, question for Stacy on the underlying bill.
Yeah, so no, I also think it's a great bill, and my former chief of staff here was here to support it. My question was, why doesn't it apply to statewide elections?
Because the Federal Voting Rights Act applies to the states, where it does not apply to counties and municipalities.
Excellent, thank you so much.
Senator Watson, you're up next.
Yeah, not being an attorney, what problem are we having in Maryland that we need this bill? I don't get it. I just like somebody just briefly explain it to me. What are they putting in place that is an impediment that this would fix?
It's a tough question. I mean, without sounding like I'm an advocate on either side, as described by the sponsor during the bill hearing, there's been some concerns in counties that their method of voting, for example, having all-out large elections, dilutes the votes of protected classes in that county, and therefore members of a protected class using that system cannot elect a candidate of their choice. And certain factors that would be in place under this bill, if they could prove those factors, could show that the system was set up specifically to specifically harm minorities, or that the impact definitely harms individuals in these protected classes, and therefore the system itself is unconstitutional due to that impact. That is what he would tell you.
Good job. Thank you.
Okay, Senator Carrozza.
Thank you. I was also trying to understand that as well. And I saw that Maryland Municipal League said that this bill would reduce local autonomy for local governments conducting elections. And I represent 11 municipalities, so I am not clear on how this legislation would impact those 11 municipalities.
It would subject them to litigation about how their election system is designed and carried out.
Okay, I guess that answers that.
Yes, Senator Washington.
It would also protect your constituents if they were experiencing or felt as though they were not able to elect the candidate of their choice at the local level, and other protections at the local level. Because right now, those aren't specifically and expressly protected in Maryland law. So again, thinking about it, protecting the constitutional, the rights of your constituents to vote.
Okay, additional, yes, Senator Simonaire.
I don't know if I missed some of this hearing, so I apologize. So, first question is are these the same protections we have at the federal level, and they're taking those same protections and putting them down at the county level?
It's not exactly the same, but yes, in impact and in intent, yes, that is the purpose of this particular bill.
Okay, and then secondly, just based on what you said earlier, would counties not be able to have at-large elections?
No, that is not the case. Someone would have to bring.
Let me just ask it this way. If some protected class said, we can't get elected in this county because you have at-large, and we don't have significant number to get that, how would the county or municipality refute that?
Well, they'd have to produce evidence under the bill in accordance with the standards that the protected class was impacted in a way that was detrimental. I mean, they have to bring the evidence. As the party moving, as the plaintiff in that case, they have the burden of showing that this particular method of election is causing the issue that they say that it's causing. So in this particular case, again, they would have to meet the evidentiary standards set forth in law. I'm not sure I could.
Help me understand. So if I'm a protected class, and I say because at large I can't get elected, what do I have to show? What's an example of I would have to show to say this is valid and you couldn't have it?
Just for example, say the population of your county, I'm going to choose a county here, has grown. 30% of your county is now African American. They have never, this population has had candidates but have never been able to be elected to a county-wide office, a seat on the school board, something to that effect. And they could show that they brought those concerns to the county government and they've discussed different methods of redistricting or a different method of election. For example, having councilmanic district or school board districts plus at large or something like that. And then, but the county has, no matter what they've done, they have not listened to this particular group, or they've continued to redistrict in a manner that the protected class determines or feels in their view is meant to continue to dilute the vote of that protected class.
Last question. So I understand redistricting, that you can maneuver, we do that in the state level. But at large is different in the sense that if there's a protected class, it's a minority, whatever it is, and they never can get elected, the fact that they're a protected class, they would have to change the election system because they can't get somebody.
Can I answer that a little bit?
I'm just trying to understand.
Just by way of an example, so you actually, this is an example, you actually have people who represent districts, but they are actually elected countywide. And so it's like by doing that, you actually have kind of like disenfranchised the group inside of there because they're not able to get their person elected because it's countywide. And let's say you put them all into this one area, but you still have the county as a whole electing in those districts. So now they got a person there who they just didn't even vote for, and that person's a district person, but they've actually been elected countywide.
So we actually do that where, say you have councilmanic districts, 7 councilmanic districts, and they're elected by the whole county? You're saying we do that?
Yeah, there's some commission places that's the case. Yes. Mhm. Yeah, different groups do it that way. So yes.
Different than our county.
Yeah, and so that's a case where then they are like, it's a design that's making it such that the folks are not able to get represented. Just to give you an example.
These are the arguments. I mean, you could accept, reject, I mean, that, we're going to
I'm
do a
just
roll
trying to
call on this
understand.
one, so, nobody's forced to vote. Yeah. Any other questions about the, okay, let's take up the amendments that, first. Vice Chair Kagan, did you say you were going to move the amendments? Okay, is there a second on the amendments? From Senator Augustine's a second. Okay, any discussion just on the amendments, not the underlying bill? Okay, all in favor of just the amendments, raise your hand. Okay, so we've got, who wants to be read on the amendments? Jason, are you taking a position on just the amendments? Okay, all in favor of the amendments, raise your hand. All opposed, could the amendments carry? So now we have in front of us, we'll do a roll call.
Second.
We've got the bill as amended, favorable, and a second from Senator Augustine. On Senate Bill 342 as amended, Lemuria will do the roll call on this one.
All right, Senator Kagan?
Aye.
Senator Kagan, yes. Senator Augustine?
Yes.
Senator Augustine, yes. Senator Gallion? No. Senator Gallion, no. Senator Watson? Yes. Senator Watson, yes. Senator Attar?
Yes.
Senator Mayor abstains, and Senator Feldman?
Okay, yes, bill carries 8-2 with one abstention from Senator Simon Ayer. 8-2 to 1, the bill carries. Next move, let's stick with you, Stacy. Senator Watson, Senate Bill 369.
Senate Bill 369, Public Libraries Automated External Defibrillator Program, the Romano A. Russell Act. This bill requires each operator of a library, as defined in the bill, beginning in January 1, 2026, to place an automated external defibrillator, an AED, in a prominent area accessible to employees and library users, maintain its functionality, and ensure that an individual is trained in the operation of the AED is present at any time the library is open. A library subject to this bill is excluded from the Maryland Public Access AED program. However, the library must register with the Maryland Institute for Emergency Medical Services Systems, MEMS. The Maryland Department of Health and MEMS must jointly adopt specified regulations to implement the bill's requirements. By December 1, 2026, MEMS must submit a report to the House Economic Matters Committee. There is definitely amendments to this bill. Page 23 and the reprint on page 25 of your packet. So this amendment removes a correctional facility library from the definition of library under the bill. And the reason for that is the AEDs are placed outside the library, and they are in an area where employees have access, but not inmates. It requires an AED operator of a library to comply with the requirements of the AED program as administered by the EMS board, and it strikes the Maryland Department of Health from the bill, as it has no role in administering the AED program. It requires the report to go to this committee as well as to the Economic Matters Committee. And there was one more thing that, and it requires to comply with the requirements of the AED program.
Senator Watson, do you want to add anything? These are Watson amendments.
These are good amendments.
Do you want to move them?
I move the amendments.
Okay, Senator Watson moves the Watson amendments. Senator Augustine is second. Any discussion on these amendments? Okay, all in favor of the amendments to 369 proffered by, okay, before we take a vote? Okay, before we take a vote, we're going to go to the vice chair.
Sorry, Stacy, could you just say the thing about the inmates again? So the correctional facilities are out because the AED would have to be,
Correctional facilities already have AEDs. They're just not in the actual library area where inmates can move about unsupervised. So those, because of safety issues, they
Okay.
have them available to
the
employees,
first
but
part
not
matters.
to inmates.
Okay,
Correct.
they're already in existence. We're
are.
not saying we don't care if you die.
That is correct.
Okay, that's helpful. Thank you.
Okay, we had a motion, a second, so we'll do a revote. All in,
Amendments?
on the amendments, all in favor of the Watson amendments on the bill, raise your hand. All opposed, the
I'd like to
amendments.
be added as a sponsor.
Okay, so we've run 369. We're going to take up sponsorship amendments, and we've got Senator Augustine, Senator Attar, Senator Brooks, Carrozza, Hester. Anybody else?
For the Watson.
Okay, Simon Ayer. Okay, I'll go Feldman. Well, Feldman's going on here too.
Come on, Mary.
And Kagan, and, okay, it's a love fest. Almost everybody, not, other than Gallion. Okay.
I'm writing that
Everybody
down.
but Gallion.
No
Okay.
galleon.
All in favor of the sponsor amendment, raise your hand. All opposed? So now we have the sponsor amendment and the additional amendments. So Senate Bill 369 as amended. Favorable from Senator Watson, second from Senator Simonaire. Make it bipartisan here. All in favor of 369 as amended, raise your hand. All opposed? That motion carries unanimously. Let's stick with you, Stacy. Senate Bill 456.
SB 456, Dental Services, Qualification for the Maryland Dent Care Program and Study on the Use of Dental Online Credentialing. The bill expands eligibility for the Maryland Dent Care Program to include dentists and dental hygienists employed on a part-time basis. The bill also requires the Maryland Higher Education Commission Office of Student Financial Assistance, in collaboration with the Department of Health, to establish prorated loan prepayment assistance for any part-time dentists and dental hygienists participating in the program. By December 1, 2025, the Maryland Insurance Administration must study whether dental insurance carriers are using an online credentialing system to process uniform credentialing forms and report its findings and recommendations to expand utilization of online credentialing to the Senate Finance Committee and the House Health and Government Operations Committee. There is one amendment on page 31 of your packet, and this was a House amendment to the cross-file House Bill 265. Essentially, these amendments strike the provisions regarding the MIA study, as MIA has said they will conduct it without the required legislation.
Okay, questions for Stacy? Has the House already moved the
Yes.
bill? I think it was unanimous. Okay, questions on those amendments? Okay, would anybody like to move those amendments?
Can I add
Yeah.
a sponsor on with
Okay.
that too, please?
Okay, if anyone wants to be a sponsor, can we just add them to this these amendments?
Yeah, of course.
Okay, anybody else want to be a sponsor to the bill other than Senator Augustine? Okay, all in favor of we'll just group it together in favor. Do we have a motion on the underlying amendments? Okay, favorable.
The amendments.
On the amendments, including the sponsor amendment, is there a second from the vice chair? All in favor of those amendments, raise your hand. All opposed, those amendments carry unanimously. We have in front of us Senate Bill 456 as amended.
Move favorable as amended.
Favorable from Senator Augustine, a second from the vice chair, Kagan. All in favor, Senate Bill 456 as amended, raise your hand. All opposed, that carries unanimously. Let's stick with you, Stacy. 534, Kagan and Gallion bill.
Senate Bill 534, Election Law, Election Judges Compensation. This bill establishes that a local board of elections must pay an election judge for each training the election judge completes only after the election judge actually serves an election day or an early voting day. In addition, for service as an election judge, the bill authorizes a public school student to both earn hours towards service learning requirement for graduation under the State Board of Education regulations and receive the applicable election judge compensation. There is one amendment in your packet on page 33, sponsored by the chair. This amendment alters the provision related to student service as an election judge to allow a student to earn service learning hours or receive compensation.
Questions on the amendment? Okay, I'll move your bill. Move the amendment. Vice Chair Kagan moves the amendment. Second from Senator Augustine. All in favor of that amendment, to raise your hand. All opposed, that amendment carries. Senate Bill 534 as amended is before us. On the bill? Yeah. Sure. Senate Bill 534 as amended is in front of us. We have a question from Senator Watson.
So did I hear correctly that a person who intends to be a judge on election day goes through training but can't be reimbursed for the training until after the election is over?
Correct.
And they've done that service?
The concern is that individuals were going to training, getting money, and then never showing up on election day, which is expensive for the boards, and then it leads to a, what do you call it? Understaffing on election day.
And that happens a lot.
So this would just allow them to be paid when all the services have been provided.
Okay, thank you.
Any additional questions? Okay, so we had a motion and a second. All in favor of Senate Bill 534 as amended, raise your hand. All opposed, that motion carries unanimously. Stacy, let's just stick with you on the second page.
All right.
Senate Bill 633.
Senate Bill 633, Campaign Finance, Political Organizations, Disclosures of Solicitation, Stop Scam PACs Act. This bill requires certain persons that solicit for a candidate or a political party and use the candidate's name, image, or likeness in the solicitation to include a specified disclaimer on the solicitation. The bill also requires certain persons that solicit for what appears to be a charitable purpose to include on each solicitation a statement that contributions or donations to the person are not necessarily used for charitable purposes and are not tax deductible. The state administrator of elections or the state administrator's designee is authorized to investigate potential violations and may prohibit a violator from soliciting contributions or donations for a period of time or impose a civil penalty of up to $10,000. There is one amendment offered by Senator Kagan on page 35 of your packet. And this amendment provides that if a person appears to solicit for an electoral or political purposes rather than a charitable purpose, the person must make a disclosure on the solicitation of the 5 recipients to which the person made the largest expenditure or disbursements during a specified period of time and the total amount made to each recipient. And it authorizes the state board to adopt regulations to enforce these provisions.
Senator Kagan, do you want to speak to the amendment at all or add anything?
We passed the bill unanimously last year, and it's really a consumer protection bill because there are folks that say, give me money and you can have dinner with President Trump, or do support our local firefighters or something like that, and it's nothing of the kind. So we want to be able to crack down on some of these, and so more transparency, more disclosure.
Senator Carozza.
So just trying to catch up. We passed this legislation without this amendment. And I guess I'm trying to understand exactly what this amendment does, especially with the 5 recipients,
Do you want to do the amendment?
how this would work in
Do the
practicality.
amendment I'll do last year.
Okay.
Okay.
So the bill had a provision that said that if there was a solicitation for what appeared to be a charitable purpose, and instead the amendment strikes that provision and says for what appears to be a, where is it, okay, rather an electoral or a political purpose, then the person has to make a different type of disclosure.
So can we walk through an example? I'm just trying to understand, especially when it comes to the 5 recipients. I mean, is there an example of an organization that we would,
I honestly,
that it would impact?
we can, Jared is not available today, but if you want to hold this and we can do it tomorrow and come back to it, or that's up to the senator.
Okay, let's
let's
hold it, and we'll try to get Mr. Demarinis here to answer that. Stacy, let's move to
My
the
last
next one,
one.
Senate Bill
Yeah.
645.
Senate Bill 645, Election Law, Gubernatorial Primary Election Date. This bill alters the date of the statewide primary election in the next year in which the governor is elected so that it is held on the 4th Tuesday in June instead of the last Tuesday in June. There are no amendments.
I'd like to explain this one.
Okay, Senator Kagan, you'd like to add
Yeah.
anything?
So I know that you all know that sometimes June and other months have 5 weeks, and sometimes they have 4 weeks. Our law currently says the election should be held the last Tuesday in June, and then it's the primary, and then it backs up for early voting and stuff. This would change it to the 4th, so in months, so some years that's no different. In others, it's it's just 1 week earlier. Why does 1 week earlier matter? It's everything from holidays like Juneteenth and Father's Day, but in addition, and really practically, it's 1 week closer to school being let out. And so families go on vacation, our school systems renovate the schools. As soon as the kids are gone, they are fixing things up, and so the schools are unavailable as polling places. Community centers have summer programs, and so the students are in there, which makes it also not available as a polling place. So this is just pragmatic, and will just shift in some years to 1 week earlier, closer to when school lets out.
Okay, any additional, any questions for the sponsor of the piece of legislation? Yes, Senator Carrozza.
I saw the Montgomery County Board of Elections was supporting. I didn't know if the statewide election officials weighed in or not, because I haven't talked to my individual county, so I didn't know if they had done a letter. No, oh, no, I saw that. I didn't know if the organization with the, right, if they went on record on this.
Mayo, the Maryland Association of Election Officials, I don't know how to say this, they will do what we set up and when we ask them to run the elections. So they are, I'm going to say, agnostic. 1 week doesn't change their jobs. And Jared had made clear that it's easy for them and it's far enough in advance that that's not going to be a problem in terms of finalizing the ballots and getting them out on time and stuff. It's 1 week.
Okay, additional questions for the sponsor on Senate Bill 5645? Okay, there's no amendments. Would you like to move your bill?
Move favorable.
Got a motion from the sponsor, Senator Kagan, on Senate Bill 645 clean. Is there a second? Senator Brooks is second. Discussion? All in favor of Senate Bill 645 clean, raise your hand. All opposed? Okay, we've got 10 yeas and 1 abstention from Senator Carrozza. Okay, let's get, April, we're going to get you involved. How about on page 2? Why don't we just start at the bottom, page 2, and we're going to work our way up, if that's okay. So start with 1028 from Senator Guile. We're on page 2, the last bill, the vote list. We're going to kind of go the opposite direction here.
All right. Senate 1028, Natural Resources, Vessels, Carbon Monoxide Warning Labels. This bill prohibits a person from operating a gasoline-powered vessel on the waters of the state unless the vessel has carbon monoxide warning labels affixed in conspicuous locations in the vicinity of both the transom, rear, and the helm steering area of the vessel. There is an amendment in your voting packet from Senator Guile. This amendment adds the short title Matthews Law to the bill and applies the bill only to vessels manufactured after July 31st, 2007. Additionally, this one is not in the packet, but somebody raised at the bill hearing a good point, which is that many vessels are not gasoline powered, they're diesel powered. Diesel is technically not a gasoline. So probably if this is to move forward, you might want to substitute and just say something like motorized vessel would more generally capture everything.
Do you need a kick? Yeah.
Well, we have to take up Senator Giles' amendment anyhow, but.
Yeah.
Move the Guile amendment.
Okay, is there a motion on the Guile amendment? Okay, from Vice Chair Kagan, is there a second on the Guile amendment? Senator Brooks, as for the use of the word motorized versus, is everybody okay with the change of the word motorized? Okay, let's take an informal vote. Okay, so we'll make that modification. Okay, we've got 1028 as amended before us. Is there a motion?
Favorable as amended.
Vice Chair Kagan moves favorable, second from Senator Augustine. All in favor of Senate Bill 1028 as amended, raise your hand. All opposed, that motion carries unanimously. April, let's go to the Howard County Senator Bill 968.
Okay. Senate Bill 968, Howard County, Patuxent River Wildland, Use of Motor Vehicles and Motorized Equipment, Howard County Bill Number 5-25. This bill authorizes the Department of Natural Resources to enter into use agreements with volunteers to facilitate the use of motor vehicles and motorized equipment within the Patuxent River wildland for the purpose of maintaining existing paths to ensure clear and safe access to the wildland. Not a formal amendment, but the amendments suggested by DNR are included in your voting packet. These begin on page 40. These would strike the bill and instead add language to the Patuxent River Wildland Statute authorizing DNR to, quote, retain, maintain, remove, or replace existing trails using mechanical or motorized equipment, and, quote, remove, replace, or dispose of non-native species using mechanical or motorized equipment. This language mirrors similar language used in the Belts Woods Wildland Statute.
Okay, I'll defer to our Howard County. Okay, we've got Senator Hester moving the DNR amendments, second from Senator Augustine. Any discussion? All in favor of the DNR amendments, raise your hand. All opposed? Motion carries. 968 from the Howard County Senators, as amended, is before us. Is there a motion? Do we have a letter?
Yes.
Yeah, we have a letter. Senator Hester moves favorable, second from Senator Augustine. All in favor of Senate Bill 968 as amended, raise your hand. All opposed, that motion carries unanimously. Devin, let's get you involved a little bit. Let's go to Senator Hester's Senate Bill 871.
Senate Bill 871, Department of the Environment, Community Water and Sewerage Systems, Cybersecurity Planning and Assessments. As introduced, this bill establishes various requirements for the Maryland Department of the Environment, the Department of Information Technology, the Maryland Department of Emergency Management, and community water systems and community sewer systems providers related to the planning and preparation for cybersecurity attacks on community water systems or community sewer systems, and the water and wastewater sector in general. The bill also amends Maryland's Public Information Act to prohibit the inspection of public records relating to the security of critical infrastructure. There are amendments offered by the sponsor, Senator Hester, on page 36 of your packet. The amendments alter some of the requirements for the agencies and community water systems. They require MDE to report on water system compliance. They strike requirements for tabletop exercises and makes other technical and clarifying changes. These amendments, if accepted, limit the fiscal effect to only require one PIN from the Department of Information Technology, which Budget and Tax is approved.
Okay, Senator Hester, do you want to add anything to the amendments? Any discussion or description?
Department of the Environment, you know, they recognized a lot of this work with us over the interim, and then there's a lot of collaboration across them, MDEM and Department of IT to get to where we are. MACO and MML are now on board, and we also have a letter from the DOD with various commitments to providing technical resources. So if anybody wants to see the letter, it's here and it's exciting.
That letter's in the last 5 minutes.
Pardon?
That's a current administration, Department of Defense.
Yes, yes.
Motion on the amendments. The sponsor of the amendments, Senator Hester. Is there a second from Senator Augustine? Any discussion of the amendments? All in favor of the Hester amendments, raise your hand to 871. All opposed? Seeing none, that motion carries unanimously. Senate Bill 871, as amended, is in front of us. Is there a motion from the sponsor? Favorable from the sponsor, a second from Senator Washington. All in favor of Senator?
Question.
Oh, yes, before we take a vote, we have a question from Senator Gallion.
Thank you. So you mentioned that like MML's good with it now, with the amendments. What about the Maryland Association of Municipal Wastewater Agencies? They were also unfavorable. Are they now good with it? Yes. Thank you.
Okay, we're going to redo that vote. All in favor of Senate Bill 871 as amended, raise your hand. All opposed? That motion carries unanimously. Let's, Devin, go up to the PIA bill, Senate Bill 555 from the Attorney General's office. That, and let me just preface it as there was pushback. There were two bills. There was some pushback at the hearing. I have had a chance to talk with Attorney General Brown with some amendments. But anyway, Devin, I'll turn it over to you just on this bill.
Senate Bill 555, Public Information Act denials pending litigation. As introduced, the bill authorizes but does not require a custodian of public record under the Maryland Public Information Act to deny inspection of a record pertaining to pending or reasonably anticipated litigation to which the state, a state agency, or political subdivision of the state is or may be a party, or an officer or an employee of the state or a political subdivision of the state because of that person's office or employment is or may be a party. The provisions of the bill must not be construed to limit any right of opportunity granted by statute or court rule for a party to a litigation to receive discovery. The provisions established under the bill do not apply to a record that is a court record or pertains to litigation that has been finally adjudicated or otherwise settled. There are amendments offered by the OAG on page 34 of your packet. Those amendments define reasonably anticipated litigation as, quote, a situation where there is concrete evidence that litigation will likely occur based on current facts and circumstances, unquote. That amendment also clarifies that the denial of records is for records that are specifically created for the purposes of reasonably anticipated litigation.
Okay, the thinking there is the bill as introduced was way too broad and kind of hard. So the Attorney General got that message and came up with this set of amendments to narrow it, tailor it. So that's the language. Take questions. If everybody's got the language. So any questions on the Attorney General's amendment language? Senator Simon-Ayer.
Yeah, I just was pulling up the testimony. As you said, there was quite a few unfavorable. Do we know how they are related to the amendments? Have they seen the amendments?
Yeah, so I did share them with Rebecca Snyder from the press, so she was actually in my office. Did she give you feedback yet on where they
She
stand?
did. So her feedback is they still don't like the bill, but if the committee is committed to the bill, these amendments are something that they can live with.
Okay, so it's a little bit of a, but you heard how, so originally they were opposed as they were with the other PIA bill that were not taken up. This one is one they quote live it. I should say that I myself got a PIA request last week involving, and I spent Saturday going through emails from 2024 for 5 months it was onerous. I mean, I'm somewhat sympathetic to, having, putting some guardrails, et cetera. But that said, that's in front of us, and any further discussion?
Can I just ask?
Sure.
I see the ACLU was against it and Maryland Coalition Against Sexual Assault. Did we get any response from them? I mean, those are significant oppositions.
So the conversation that the chair had with Ms. Snyder indicated that she was representing the coalition of folks that were opposed to the bill, but we have not gotten anything specific from the ACLU.
That's all I can represent is she indicated to me that she was sort of representing, she was the only one that testified in person, sort of representing the coalition of folks who didn't like the bill as drafted. So that's all I got for you. We have the AG's opinion, amendments, but let's kind of take a vote. Let's discuss it. Senator Kagan.
Chair, this amendment came from the Attorney General's office?
Yeah.
So the A, in this section, reasonably anticipated litigation, got it, means a situation where is a location, there is concrete evidence, concrete is definite, 100%, evidence that litigation will likely, which is not definite, occur based on current facts and circumstances. I mean, that language is just, it feels internally contradictory and imprecise. And this is where my grammar geek word nerd person is coming out. This just doesn't seem solid to me or clear.
Okay, I guess I might.
Do you disagree? You're the lawyer.
Well, I think that, at least the intent here is clearly.
The intent.
Well, okay, let me look at
But
this language
we're
again here. I mean,
putting this
I think
into
it's
law
putting a
book.
pretty heavy burden on, okay, I don't want to misstate the actual language here.
Maybe this should be something council plays with or something to
So
take it up.
Senator, the language from the Office of the Attorney General here mirrors the definition that the Attorney General uses with regard to reasonably anticipated litigation.
Okay,
This
so-
is a standard definition that they that they use in the Office of the Attorney General.
These precise words.
These precise words.
Okay, so concrete and then likely, like we think, but it has to be, and then only current facts as opposed to stuff we, okay.
Well,
If this is what
but you're mixing a couple things. Concrete is referring to the evidence.
Understood.
As far as the likelihood of litigation, that's a separate, so they're not, I don't see how those are inconsistent. Having concrete evidence and the likelihood or highly likely, I mean, to me, those are,
I don't even like the word.
well, you may
where.
not,
A
but.
situation where there is concrete evidence.
Okay, well, I think Devin's suggestion is we
Okay,
might have to
if this is common.
reword all portions of the, okay. But so if your people think it's vague and people don't like the bill, you can vote red. That's fine. That's why we're here. Okay. Okay, Senator Augustine moves the Attorney General's amendments. Is there a second? Second from Senator Carrozza. All in favor of the AG amendments, raise your hand. All opposed, the amendments carry. We now have the bill as amended, and we're specifically, we've got the bill, Senate Bill 555 as amended before us, and we'll do a roll call on this one, Lemuria.
All right, Senator Kagan?
Pass for now.
Okay. Senator Kagan passes. Senator Augustine? Yes. Senator Augustine, yes. Senator Gallion? No. Senator Gallion, no. Senator Watson? Yes. Senator Watson, yes. Senator Attar? Yes. Senator Attar, yes. Senator Brooks? Yes. Senator Brooks, yes. Senator Carrozza? Yes. Senator Carrozza, yes. Senator Hester? Senator Hester abstains. Senator Washington? No. Senator Washington, no. Senator Simonaire? No. Senator Simonaire, no. Senator Feldman?
I will go yes, so that is 6 to 3 to 2, is it? Oh, yeah, 6 to 3 to 2 abstentions? Is that
Yeah,
accurate?
you can change me to abstention.
Okay.
Okay. Okay, 6 yea, 3 no, 2 abstentions. The bill, Senate Bill 555 carries. Let's go back to page 1. Devin, let's go down to Senator Guile on Senate Bill 491, and I think Senator Simonaire was involved with coming up with some modified language. Devin, describe Senate Bill 491.
Senate Bill 491, General Provisions, Veterans Benefits, Honorable Discharge. As introduced, this bill, with respect to any state program of benefits, rights, or privileges applicable to a veteran under Maryland law, alters the definition of honorable discharge to include a discharge that is less than honorable based upon an incident or incidents relating to either a diagnosis of PTSD or traumatic brain injury, made by an individual licensed to provide health care services at the U.S. Department of Veterans Affairs, or an experience of sexual trauma as described under federal law disclosed to an individual licensed to provide health care service at a United States Veterans Affairs facility. There are amendments offered by Senator Simonaire on page 32 of your packets. The amendments strike the provisions of the bill and simply authorizes the department to allow benefits to be awarded if the department determines that the discharge should be upgraded based upon specific provisions of federal law. And also Senator Simonaire and Senator Kagan would like to be added as co-sponsors.
Okay. Senator Simonaire, you want to add anything about the amendment that you crafted?
So I worked with the sponsor, I worked with the department and the Maryland Military Coalition, and this is the amendment that brought everybody together.
Okay, who would like to be on this bill as a co-sponsor? Okay, Devin, we've got Brooks, Carrozza, Hester, Washington, Attar, and Augustine. Anybody else? Okay, first up, all in favor of the sponsor amendment, real quick, raise your hand. All opposed, that amendment carries. The other amendment from Simonaire, Senator Simonaire, you moving that? He moves that favorable.
Second.
Vice Chair seconds. All in favor of that amendment, raise your hand. We now have in front of us, we've got Senate Bill 491 as amended before us. All in favor of 491 as amended, raise your hand. All opposed, that motion carries unanimously. Devin, let's go to Senate Bill 309 for Senator Simonaire. Bill?
Senate Bill 309, Department of Veterans and Military Families Online Registry. As introduced, this bill requires the Communications Outreach and Advocacy Program in the Department of Veterans and Military Families by December 31st, 2025 to establish and maintain an online registry to provide information to registered individuals. The Secretary must include in their annual report specified information related to the online registry. The bill also alters several definitions related to the military. The appropriate amendments are offered by the sponsor beginning on page 7 of your packet. The amendments remove the requirements of the online registry. They also add additional requirements for the Communications Outreach and Advocacy Program to assist service members with accessing benefits. Finally, the bill adds service members to the provisions of the bill and otherwise conforms the bill to the language that is in the Omnibus Military Bill, Senate Bill 275.
Okay, Senator Simoner.
So what initiated this was I tried to get information about our registry that we have uncodified, and there's really a lot of potential there because we don't know how many veterans on it, how many spouses and so forth. So I came up with an idea. The fiscal note kind of sunk that this year, so I'm going to work with them on the interim on that part, but we agreed to get some more information about the communications and also update it based on the mission statement and their new name. And everybody agrees. Department's good with it.
Okay, do you want to make a motion?
Move favorable on the amendment.
Okay, we've got okay, we could do that. Who would like to be on this piece of legislation as a sponsor? Senator Carrozza, Brooks? Anybody else? Okay, all in favor of that sponsorship amendment, raise your hand. All opposed, that carries. On the other amendment, favorable from Senator Simoner, second from Senator Washington. All in favor of that amendment, raise your hand. Okay, we now have in front of us Senate Bill 309 as amended. All in favor, raise your hand. All opposed, Senate Bill 309 as amended carries. Folks, I did tell you that we would just go to 6 o'clock because we got a 7 o'clock session. And I know everybody's super hungry. Okay, so first of all, on 170, the only two bills left here on the 175, I know you guys are here for that. You know, we did get an amendment was being floated around here. There was a question about, I'll just put it out there, who's doing the study, whether we might want to discuss. So let's defer that till tomorrow. And similarly, we do need to take up this MDE bill, which we've been slow playing, to be honest with you, but this will be like the first bill we take up when we vote tomorrow. And so let's just stop there. And these will be two bills we left. Meanwhile, we got through everything else. And so I think this was good after the afternoon, which went a lot longer than I had thought. So see everybody on the floor and we had a hold on here too. So yeah, a couple, yeah. Okay, so the meeting's hereby adjourned. See you on the floor at 7 o'clock.